Well, good day, everyone. My name is Mike Daiello. I'm an attorney and I represent estate executors, helping them settle estates efficiently and reduce stress. Thank you very much for joining me today for this interesting topic on estate properties. If you have not heard the term estate, that simply means when someone passes away and leaves money or property, especially real estate. An estate must be open for the deceased person and a personal representative appointed. This person is called the executor or the administrator of the estate. And attorneys and others also call this process probate. Now, there are many different kinds of estates, from very simple estates where the family is in harmony and there's no legal roadblocks, to some situations that are highly complex where a family property might be entangled with many legal issues and many people who have an interest in the same property. My goal is to help families complete the entire probate process so that the real estate can be sold. And I handle the administration of the estate and resolve any legal problems that might surface along the way. So today we're going to cover the basics of the estate administration process, especially from the perspective of real estate, so you can better understand what to expect. Okay, so let's jump in. There are two things that you can do after today's presentation that will help further your education with estate property issues. And I would tell you, first of all, to go to my website. It is PennsylvaniaProbateLawFirm.com. And there is a free download available called the Pennsylvania Probate Handbook. I wrote it myself. It's designed to help people who either need to go through the probate process as the representative of an estate, or for someone who is assisting someone, such as a real estate agent or an investor, who is helping someone get through the probate process so the property can be sold. I promise it's very good. I think that you'll like it, and it'll be very helpful to either help you get through the process or assist somebody who does. And also, you can connect with me on social media. I'm on LinkedIn, and I have an Instagram page called Pennsylvania Probate Law Firm. Both of those have resources and guides and tips about navigating the probate process and all of its complexities. So grab your handbook. It's very good. You'll enjoy it. And also connect with me on social media. I'd be happy to do that with you. Okay, so let's talk about estate and probate issues. All right, so when we are talking about estate properties specifically, that part of the estate tends to be one of the more complex areas that you would be dealing with in the estate administration process. So how do we avoid delays in selling this property? One of the keys to doing that is to understand what is expected of the person who's going to serve as the representative. When a deceased person passes away, the property cannot be transferred by anyone until the representative is appointed for the estate. This is what we call opening the estate. And once the estate is open, the administration of the estate can be completed, and then and only then can the property be sold. So how do we do that? Well, estate administration is basically broken up into 4 stages. And I break it up into these stages because I think it makes sense, especially from the standpoint of real estate, to know what steps are needed in order to be able to proceed to closing on an estate property. So stage 1, I call information gathering. And this is basically where we gather the prerequisite documents that are going to be needed to present to the probate court, called the Register of Wills. So you need an original death certificate. If the deceased person passed away with a will, you'll need that. And there's a number of other things as well that you might need depending on the individual circumstances. For example, a renunciation in favor of certain heirs who might defer to another person who would be selected as the representative of the estate. So what I do is I maintain a checklist, and when someone comes to me for problems with estate properties. We just go down the checklist and make sure we have everything that's needed. But talk to them, first of all, about the death certificate and the original will, or if you want to serve as the representative, make sure that you gather those things, because you can't get far without the originals of those two items. The next is petitioning for grant of letters. So what are letters? Letters are basically the authorizing document that is given by the Register of Wills to authorize someone to handle the legal and the financial affairs of the estate. And this part can be very easy, or it can be very complicated depending upon what exactly needs to be done. But in the ordinary course, if the estate is not complex and it's just a matter of opening the estate with no special legal issues, it's not a very lengthy process. It usually can be handled in less than a half a day. Once the letters are issued, that is when the real work begins of administering the estate. So the legal authority is given, and then all the usual things that someone has to do to administer an estate begins. So, for example, preparing and file the inheritance tax return, inquiring with certain government agencies to see if there's any liens, publishing the estate, dealing with creditors, handling special issues that can come up, dealing with beneficiaries who want to see distribution made to them. There's a lot of different things that are done in administration, and each estate is different depending upon who the beneficiaries are, what kind of assets are in the estate, whether there's a will. It all varies from one estate to the next, but most of that work has to be done, or at least a substantial part of it, before the property can be sold. And then we go into the final stage, which is distribution and closure. So that's when, for example, all the money and the property in the estate is distributed to all the beneficiaries. And that would include closing on the real estate if it's going to be sold. So next question then is, all right, naturally, who is the person who's going to serve as the representative of the estate? And what are some of the things that we have to think through to avoid future delays? Because I always say that an ounce of prevention in probate is worth a pound of cure. You hear that all the time, but it absolutely makes a lot of sense for probate. Probate is a very step-by-step process. And if you don't anticipate things that could be roadblocks later, it just extends the time that it takes to go through probate. So who will serve as the representative? Well, this depends on whether or not there's a will. And I want to say that everybody should have a will, because one of the functions of a will is to make things easier for your family members when you do pass away someday. And one way you can do that is by naming someone to be the representative of your estate. It also helps avoid delays and disputes with family members at a later time. So let's assume that there is a will. The first thing the representative must do is file a petition with the probate court called the Register of Wills, take the original death certificate to the register, and if the register is satisfied that everything is in order, they'll issue what's called letters testamentary. If there is no will, then the law gives an order of priority as to who may serve. Now, to keep it simple, this order is first to the surviving spouse and then to the children in most cases. But any person who has priority can renounce in favor of another person. So, for example, if the surviving spouse preferred another person to administer the estate, maybe they're don't have the skills and tools to handle financial and legal issues. They say, okay, well, maybe I am listed in the will as the representative, but I prefer my son to handle this for me. They can do that through a simple one-page form called a renunciation. Now, if there is a will, but the original is lost, this is a common question. Is the will still valid? Yes, it most likely is, but this requires a special petition before the Register of Wills to admit the copy into probate. It's not a guaranteed right. You have to petition and then receive approval. And obviously, this is more time consuming and expensive. It causes delays, and there are costs involved in pursuing these petitions. But the good news is that as long as all of the beneficiaries or heirs to the estate are not contesting the validity of the copy of the will, the Register of Wills is almost certainly going to admit the will, a copy of the will, into the probate. The issues come up when the original is lost, but some people who have an interest in maybe there not being a will, maybe their financial interest is better if the law, if the estate did not have a will, that's when some of the challenges come in. You can imagine some situations where perhaps the persons who have priority for serving as an estate representative are, say, for example, 4 surviving children. But one of those children is not on good terms. If one of those children cannot agree on who will serve, or they can't agree on whether or not the copy of the will be admitted into probate, this is one of the issues that can come up. And so naturally people ask me what can be done. If one of the heirs wants to serve as representative, but there's a holdout, or they won't, or the holdout won't sign off on that person becoming as the representative, or on having the will admitted as a copy into probate, these are the kind of cases where litigation commences, where you have petitions before the Register of Wills and you have hearings to determine who's best to serve, whether or not the copy of the will can be admitted, things like that, and you have to present your evidence. So naturally, that's one of the ways that you can evaluate something that you might be facing. If you're thinking about, well, what are some of the challenges I might face? Do you have the original death certificate? Do you have the original will? Do you have all of the heirs on board? Is everyone cooperative? People generally agree about what should be done to assist with the family members settling of their estate with dignity. If that's the case and everyone's on board, it makes things a lot easier. And it makes you get past some of those initial roadblocks and just get on to the important administrative work. So what are some of the things that you have to do once you get into the administration process? Naturally, the representative just asks us, okay, what things do you actually have to do? And so the basic things are inheritance tax returns, opening the estate bank account, filing the inventory with the Register of Wills, sending the probate notices to heirs and creditors, and basically publishing the estate and making sure that all the people who have an interest in the estate are satisfied. Obviously, like I said before, every situation is unique, and some estates have much more complexity than others. But the things that we just discussed a moment ago are the things that are common to every estate that have to be done. So what are some of the common property roadblocks? We've talked about some things that are roadblocks to getting the estate process started, not having the death certificate, for example, or the will. But what are some things that are specific to estate properties that can cause a delay in going to closing? People often ask me, why does probate take so long sometimes? What are some things that cause delays in going to closing? And so these are some of the things that I see over and over again. 3 of them in particular, you can see on the PowerPoint, that can cause delays in proceeding to closing. So the first is when the family is estranged and they're missing. So a common example of this would be that a property was purchased by 2 married people, and then they became separated for 20 years. But the property was not titled in the surviving spouse's name. Maybe someone is in a situation where they were married but never officially divorced, and that means that most of the time the surviving spouse still takes a share of the inheritance. And they also have rights to the estate, even though they might not have been in that person's life, or maybe they may have been involved in a way that is not normally the way that spouses would interact with each other once they become separated, but they still may have inheritance rights, and they most likely do. So this is one of the common roadblocks, and they may contest part of the basic parts of the estate process. They may say, well, no, I want to serve as the representative of the estate, or I think something different should be done with this property. Maybe it should stay in the family, or maybe it should be sold. And when people who are non-cooperative or missing, even perhaps maybe the surviving spouse or some child is not even known where they live, that can certainly slow down the probate process. The second, people often tell me that this is a nightmare for them and for the family when properties are entangled by multiple estates. These are situations where, let's say, for example, your grandmother died without a will, and there's real estate in her estate. She had 4 children, but for whatever reason, the estate just wasn't open, and the property was not transferred to the heirs, and it wasn't sold, just stayed in grandmother's name. And years go by. And then what happens when the children who should have received the property from the grandmother also begin to pass away? Now the children of grandmother want to sell the property, but some of those children have already passed away. Let's say 2 of them have passed away. Well, the estates of those 2 children have an interest in grandmother's property. And so after all those years, now you have 2 estates and 2 children who have an interest in the same property, which means you have a total of 3 estates that would have to be open. And naturally, the people who might be in line to serve as the representative of the deceased children's estate would be the grandchildren. And so those people have an interest in the property, and they have an interest in this whole process because of the interest that their parents had in grandmother's estate. And this can get very complex. I've seen situations where there's 15, 20 people who have an interest in either the property or the estates of people who died and have an interest in the property. And so you come into a situation where you're dealing with a lot of people and a lot of estates, and certainly there's a lot of work to be done, but also it raises the possibility that people will be uncooperative. So if you see one of those situations, it's good to consult with an attorney before you embark on either trying to sell the property or dealing with other family members, just to get an idea of what things would have to be done and lay a roadmap out for untangling a property that's in a situation like this. And the third common situation I see that is really perplexing to people is when someone dies with an interest in property that was jointly titled with another person, and that person's still living. So maybe grandmother owns a property with one of her children. Grandmother passes away, and her estate then becomes 1/2 owner of the property with her son. And depending on how it's titled, might not automatically pass to the son. It could be 1/2 to the grandmother's estate, whoever those heirs are, and 1/2 to the son. And sometimes the son, who is 1/2 owner, may not necessarily have the same view as to what should happen. Maybe the son wants to keep the property and buy out the interest of grandmother's estate. Or maybe there's a disagreement about when that should be done, what the buyout price might be, things like that. And so it certainly can create delays and the possibility for disputes. So these are just some of the probate issues that you can encounter. There's many more pitfalls, whether they're related to real estate or any other kind of asset. And navigating all these responsibilities is certainly a challenge. And even more so if there's certain family dynamics or estrangements that can add to the feeling of overwhelm. So one of the key things that many people don't realize is that an estate representative takes on the risk of personal liability when they accept the appointment as representative. This means that If any mistakes are made in the process of administering the estate, whether it's the inheritance tax return, distributing property, handling creditor claims, the cost of any major mistakes can ultimately be charged on the personal representative in the personal capacity. So if you have a situation where the estate maybe doesn't have enough money to satisfy all the beneficiaries and creditors, and distribution is made the wrong way, this can be a situation where the estate representative has to go back to the beneficiaries and say, look, you need to pay this money back to me, or maybe they end up paying out of their own personal pocket. And the same kind of roadblock or mistake can come up when dealing with government agencies. Maybe you make distribution too early before you find out if there's any Medicaid liens, or if the inheritance tax that you estimated was the correct amount before you made distribution to beneficiaries. So just keep in mind that respect the position and respect your own liability or potential liability when you accept the appointment as personal representative. I've helped many families resolve these kinds of estate issues and avoid probate pitfalls in that process, including avoiding personal liability. And I do my best to make sure that every aspect of probate stays on track and the estate is closed on time. So if you, like I said, if you are very interested in estate properties and estate property resources, I produce some great materials both on Instagram and LinkedIn. Just connect with me on Instagram. It's at Pennsylvania Probate Law Firm. I'll show you that right now. At Pennsylvania Probate Law Firm for Instagram. And LinkedIn is just my name, Michael Daiello. And you can get the free probate handbook at the link below that's shown on the screen, PennsylvaniaProbateLawFirm.com, and there's a sublink to the probate handbook. So thank you very much for watching the presentation today. I hope the information was helpful to you. And if you are faced with a probate process, whether you need to go through probate as a representative or you are assisting someone, maybe as a real estate agent, a financial advisor, a real estate investor, anyone who is helping someone and you have questions about a potential situation, please call me or reach out to me through my website. I'd be happy to talk with you about the problem, and we can decide if representation makes sense. Thank you very much for